Hey, wewe si genius.
Bana. My
bro mazangu hajazaliwa. Uongo. Alikuwa
ulimpata kwa gate. Anasema ulikuwa 2016.
sasa vipi la
ilikuwa
kubwa machine.
No.
Kwa jamaa anajua kila mtu. Kwa unajua kila mtu bro.
No people.
By then ni hulka ya watu wazee kujua watu. Anaanza kunia hapa kisawe. Ni hulka. Kisawe cha kumwa na kichwa.
Kisawe cha kumwa na kichwa.
Tumengoja miaka ngapi? Hulka. Hata sijui nimesema nini lakini najua hulka ni tabia. Acha Kiswahili ya Raima. Wewe mluyo utakosa aje.
Hulka cha kumwa na kichwa.
Unajua ukitumia akili sana za Raima za gagro kwenye
Gagro
kwa mavazi
ama hiyo
na gagro ama hiyo
kwa nini exactly
ama yana kisi yake bana
gagro na
Acha tuuliza Kalen. Unaweza unajua gagro ni Wewe kwa basila basi.
Hiyo nayo iko.
gagro iko bana. Wewe unajua surupwenye?
Sio bana.
Gagro ni overall.
Godoro.
Ndio ilikuwa inaitwa shimizi.
Shimizi.
Shimizi ya. Wallahi ilikuwa the interchangeable.
Hii ilikuwa inaitwa aje?
Gumba.
Gumba. Hiyo jamani alisema gumba.
Ndio maana ameupika.
Wewe Shamsi ni nini?
Si ni mtu.
Buda ilikuwa Shamsi.
Niliamka asubuhi na mapema kabla Shamsi hajapiga mayowe ama ndio.
Bro.
Hapana.
Zile insha bro. Ndio. Kwani nyinyi mlikuwa mnaandika nini kwa insha?
Kwani nyinyi
Ulikuwa na lead mob.
Zile insha za
unaanza aliingia na
Yeye ndio
ati
anza insha na maneno yafuatayo.
Mwalimu kutoka US. Group of schools wana.
nani anaongea?
Group of schools.
Nani anaongea? Nani anaongea?
Nilikuwa na mwalimu wa course.
Soita
ni wakwetu mzuri.
Soita shitana.
Soita ni Mluya. Soita ni Mluya.
No wonder unapita zetu.
Lakini sema kwa kusoma insha zenu mpaka nikafikia.
Hapana,
Kila siku
wewe ulikuwa
wazanisha from insha
amjapatana na St. Paul's St. Vincent de Paul.
Kila mtu alikuwa anamaliza insha na wahenga na waenguzi. Hawakupaka sijui.
Good evening once again. Ishmael and I'm the moderator for today's webinar.
Alafu unanini
Today we're looking at human rights, plus the constitutional aspect and its governance. As we all know, human rights are fundamental principles of freedom
alafu unamalizia
and justice for people. More so in our jurisdictions, more so in Africa, for example, in Kenya, human rights are the core of governance. We're going to kick off the conversation with Wakili Anthony. We have Jessica Damar and Stephanie. Now, Anthony will take us through a few areas on human rights governance in Africa, and Jessica and the challenges that you said we faced as a continent since constitutionalism. When we speak about constitution,
hapo kwa Moi hatuwezi. Hata miss lakini siwezi ongelea Bunyore naye. Nikao Sambo Jero.
I work closely with the Amnesty International Kenya, having served in the board. I also engage with AMCA Africa Justice Initiative and so many other. Yes, but in brief, I'm a human rights defender. Country Kenya.
okay, Jessica, you may proceed with the introduction first.
Thank you very much. Jessica Damar. I'm very pleased to be part of this conversation today. I'm a lawyer by profession.
panelists for tonight because of that well done introduction part. Now we're going to discuss and dive deeper into human rights and assess the standards to which African nations have protected human rights and how they defend them in case of a violation. For today, Jessica is gonna start with that particular introduction. She prepared it prior. I know she's well versed in human rights and that stuff. Then we'll proceed to Akolo Anthony, and Stephanie is gonna take us through advocacy and advocacy part of the human rights. How do we actually persuade people to adhere to human rights principles? So after Jessica and Anthony address the human rights in Africa and challenges thereon, Stephanie is gonna come and now tell us what we need to do to ensure that government actually protects and the people are aware of their rights. Thank you so much. I'm gonna ask Jessica to start. Jessica.
Thank you very much. I'm glad that this conversation is coming after we have turned 15, particularly in Kenya. Our constitution has just turned 15 and it has put us in a reflective position to look at what is happening in terms of constitutional compliance and all that. But to address your question on the landscape across Africa, I would say the story of constitutionalism and human rights in Africa is one profound contradiction. Because on one hand, we have a wave of democratization that is led by adoption of progressive constitutions, Kenya being a prime example of that, because it's lauded for having a very robust Bill of Rights, a devolved structure, and an emphasis on public participation. But on the other hand, we find that there's a distinction between the, robust progressive laws and the reality on the ground. On one hand, we have citizens who remain starkly disconnected from this legally or rather lofty legal ideas. And then we find that there's also a disconnect between the implementation of these laws. So we'd see that different countries have come up with progressive texts, modern constitutions, you would call them. And we cannot even say that they are a copy of the Western models because they bring in innovative and compelling point of views that are very accommodative of our way of life. They incorporate socio-economic rights, environmental rights, and the rights of marginalized groups, women, children, and persons with disabilities. But we see that still there's a disconnect in terms of how these laws are implemented. Another thing we can see as a challenge probably to the constitutionalism in Africa is that there are vibrant judiciaries. There are judiciaries that come in to enforce the text and the letter of the constitution. But then we see that sometimes there's lack of willingness to check executive power, and it can be for a number of reasons. Sometimes the judiciary is held, and controlled by the executive powers. Sometimes there's even lack of resources to effectively deal with these issues. You can see like backlog of cases, operational inefficiencies, and all that. But let's not even think about the judiciary alone, because there are other institutions that are in place to ensure that the constitutions are brought to life, and these are independent institutions that come in to enforce the human rights, or rather, even not human rights alone, but the constitutional positions that are laid out in constitutions. So we have like institutions that come to breathe life to the constitution, and we can attest that lots of these organizations or institutions face a myriad of problems again, so there could be intimidation in terms of even independence of commissions. We see that sometimes there's lack of independence. We see that sometimes the operation is ineffective, because I usually refer to this video on TikTok which says that if you wake up in if you work in an institution that is a government institution, you just wake up and sleep. It's translated to a song that's done by the greatest band in Africa, which is Sauti Sol. Kwamuka, kungara na kukatu, which means you wake up, you look good, and you just sit. So those in operational efficiencies sort of challenge the effective, or rather give a threat to constitutionalism. Yeah. And yeah, those are some of the things I can say with regards to our constitution. I'll also want to belabor on, of course, the things that we know, like maybe constitutional coups. Rather than military coups, we see now there's something that we call constitutional coups. And this is basically manipulation of legal and constitutional processes to extend presidential term limits, to erode democratic institutions. And this is a phenomenon that we have observed across different nations in Africa, which is led by, I think, the cancer that is facing Africa, that is corruption. And I hate to be the person who is like very negative in terms of the review that we have as a continent, because sometimes there is a positive side, and I'll say the only positive lens I see is that there's an existence of laws, there's an existence of legal frameworks that support rights, that support the promotion of socio-economic rights and all that. But then when it comes to the to making these laws become operational, there's a stark contrast. Yeah, so that is my high-level overview of the position we're in as Africa with regards to our constitutionalism and our human rights observance.
Okay, thank you so much, Jessica, for that wonderful conversation and your presentation on our current position as Africa as regards to adherence to human rights principles. As we proceed, I'm gonna kindly ask if you can, you turn on your camera, because this conversation is live on Falas Kenya page on YouTube. And for those who have not had time to join now, they may refer. Thank you. Anthony, you may go on to share your insight on human rights standards in Africa, and also you may highlight a few challenges that we have. Jessica, we have a few questions for you, but they're gonna come after all the panelists. Thank you.
Okay, thank you. First of all, in regards to turning on my camera, apologies, my bandwidth of internet won't allow the same. Then I'm also not in a very nice environment. So
Okay, you may proceed.
just to give my views in regards to constitutionalism in Africa and the challenges we are experiencing, I'll say I highly align with Jessica's views. And looking at two countries that have been said to be having one the best constitutions, that is Kenya and South Africa, I think I would love to experience how things are in other countries, because if this is the best, then we have a long way to go as a continent. Because having come from Kenya, I feel like constitutionalism is a dream, and I hold the view that those who are supposed to safeguard the constitution are the ones who are defining the same constitution. I hold the view that there is some sort of unity that is there in different blocks. And I'll say in regards to the East African bloc, and I've been very vocal in regards to how the East African bloc is united so as to ensure that they oppress human rights defenders, they oppress those people who are expressing their civic rights and so on. You realize that there is, I normally say they read from the same book. Look at what is happening in Kenya, Tanzania, and Uganda. There is some sort of unit, negative unit, where it's very easy for someone seeking refuge in Kenya to be deported illegally back to the country where this person is running from because of, we normally call it prisoners of conscience. Because of the views that you hold and so on, you are put behind bars. So in regards to constitutionalism, I'll say that we are so far from what is regarded as constitutionalism. It's a dream that you're living for. But just as it is said that I do believe that it's a dream that will come to pass one time, because having seen how people are rising to defend their rights and the rights of others, it's something that it's attainable. I believe that my fellow panelists will be telling us on how we can unite for common purpose and fight for the constitution. That is in regard to constitutionalism. Challenges, we do face a lot of challenges. There is lack of civic awareness where people don't know their rights and so on. I feel like also we are in a state where justice is for the rich. And I'll use an example of what has been happening in Kenya recently, where the state is criminalizing just like terrorism that attract a very high amount of bail. I know fellow human rights defenders who have stayed behind bars just because they cannot raise the bails in offenses that even the judge know that these are offenses that are not true. So I'll say that still justice is being how do I say justice is for the rich, and I believe that this is a problem that is cutting across the different African nations. I rest it at that point. Back to you, moderator.
Thank you so much, Anthony. We're getting questions, but I hope all of you are comfortable with answering the questions later for the convenience. You just said justice is for the rich, but we have independent institutions like the judiciary that should check on that, and they are primarily for justice. So I'm getting some questions for you, but we'll get back to that later. I'm gonna welcome Stephanie to tell us the advocacy part and persuasion to make sure that at least human rights standards are adhered to and well protected by the government, because a government exists to protect its people, and then a government cannot exist if its primary goal is to abuse human rights by killing people and doing all that bad stuff that they do by use of criminal justice system, more so the police. I have questions to Jessica regarding the Kenyan situation and crackdown on protest, but those will come later. Stephanie, you may proceed, and very much welcome.
Thank you, everyone. So first, I would like to speak about the Constitution. So when we speak of constitutional rights, we often think of the beautiful words, excuse me, in our Constitution, which guarantees freedom, dignity, equality, and other benefits to a citizen of that particular country. Now, we have to remember this, that a constitution, no matter how noble it is merely paper until it is defended. And it is through the art of advocacy and persuasion that these words in the Constitution come alive. And so before I continue, I would like to state that it is very important as soon-to-be lawyers, and as law students to study the law very well. Because a good lawyer is the one who knows where to find the law and who knows the art of advocacy. If you do not know the law, you will not be able to advocate for any person. And if you know the law and you can't advocate, you cannot win. So these two are very vital in your study and in your journey as a law student or as a lawyer. So now I want us to reflect on what it means
Hello, Stephanie, your microphone is muted. So kindly.
Hello, sorry, apologies. I think that was a mistake. So I'd like to reflect on the art of advocacy and persuasion in terms of what it means and how it operates and why it is so crucial in our various countries in Africa. Now we're starting with advocacy as a shield of constitutionalism. Advocacy is not just the business of lawyers. It is the duty of every citizen who has a voice to say that this is my right and this is my constitution and my rights must be respected as well as the constitution must be respected. Now in Ghana, our constitution has a whole chapter talking of the fundamental human rights of citizens as well as rights of foreigners in the country. Now, but these rights do not enforce themselves. They require a courageous voice, a persuasive reasoning, and then strategic confrontation with the powers. And the powers would mean the courts, but you would agree with me that parliaments can also be a power, because in certain situations you would have to defend a bill before parliament, before it will be passed to become a law. So the art of advocacy does not only end in the court or begin and end in the courts, but also in parliament and in our daily lives when it comes to contracts, when it comes to contract law and other business areas, you would need to use the skill of advocacy. In Ghana, for instance, when it comes to enforcement of human rights, we have a particular court which is in charge of listening to human rights cases, which is the High Court of Ghana. So the High Court of Ghana is the only court that is blessed with the power to listen to human rights cases. And these are supposed to be personal. Human rights are personal, so personal human rights cases start and begin in the High Court. Of course, there are issues of appeal which can go to the Court of Appeal and then the Supreme Court, but a human rights case will not begin in a district court or a circuit court. It only has to be in the High Court in Ghana. So I believe that all these things are very important. That is why I mentioned that education, knowing the law, is very important as a law student or as a lawyer or as a soon-to-be lawyer, because imagine having to go to court, instituting an action against an individual, a corporation, and you institute it in the wrong court. Not only does it show that you are incompetent, it also slows down the process in court. You understand? And these human rights cases and issues are very sensitive. And so the faster, the better. As most times the victims are traumatized and cannot go into the whole litigation process without help. Now, in Ghana, we have cases like the New Patriotic Party versus Attorney General, the SIBA case, where we discuss the powers of associations, the rights of associations. We've also discussed cases, there are also cases like 241 Attorney General, number 2 versus Attorney General. All these cases, case law, very important as a law student, speak to the enforcement of rights and who can enforce this a particular right, which is also very important, which comes back to education. You need to understand who has the capacity to enforce the right, who has that right in the beginning, because there are certain rights that are akin to just citizens, and there are certain rights that would also reflect on foreigners. So a foreigner may not have the right of will not have the right of a citizen, and therefore cannot enforce certain rights in our constitution and certain human rights in our constitution, as they are not citizens. So for example, in the case I mentioned, Psalm number 2 versus Attorney General, the courts defined who a person is. And in our constitution, Article 2, it speaks about where a person is of the opinion that his right or this an act or omission that is in contravention with the constitution, that person may bring an action in court. So in that particular case, the courts defined who a person is. When you say a person can or a person may, doesn't mean that any person at all, once you're in the country and once you feel like the provisions of the constitution by a person's act or omission is in contravention with the constitution, and then you can start or institute an action. So the court, what the court did was to define it that a person is a citizen of the country. In another case, MPP versus Attorney General, the SIBA case, the court also indicated that a person in the previous article can also include an organization, an association, right? So all these things are very important because the Constitution as a body or as a document on its own may not be understood if the cases that relate to it or cases that have spoken to certain articles in the Constitution are not understood. So for example, as a lawyer or as a law student, it's not just reading the Constitution, not just reading the laws. It is very important to look at the application of the law because that helps in your advocacy. So if a case comes before you and you know that, oh, in this case, the Constitution mentioned that a person is a citizen of the country. The person that's going against you is not a citizen of the country. You have a point, but this is not directly in the Constitution. So that is very important in your act of persuasion and advocacy. If you do not know the law, if you do not know its application, you will not be a successful advocate. Now, let's look at the art of persuasion in rights litigation. So persuasion is an advocate's greatest weapon. I think we can all agree to that. It is not enough to know the law, and you must be able to speak the law to heart. Now, the first thing to think about is legal reasoning, mastery of the constitutional provisions, precedents, and comparative law, like I said. The second is storytelling, translating legal violations into human experiences that the judge and public can feel. Now, we all understand that sometimes public opinion is important when it comes to the court of law and justice, attaining justice. And so in certain situations, you have to, not in certain situations, in all situations, you have to tell a story to the court. Most times people talk about, I do not know if you've heard of a movie series called Suits. People watch Suits and they are so interested in the law and wanting to become lawyers because of the movies and the series that they watch, because of the art of advocacy. That is what attracts them. And it is attractive because of the storytelling. You have to convince the judge, or in criminal cases, you have to convince the jury. You understand? So that they are on your side and they understand the point of the victim or the person that you are defending. Okay, so that is very important. And the third is rhetorical and language. The careful choices of words, analogies, and moral appeals that move the conscience of the court. It's very important. So the next thing I would like us to talk about is advocacy beyond the courtroom. So advocacy does not end when we step out of court. It extends to the media, to classrooms, to market squares, as I mentioned earlier in the introduction, about contracts and other situations where we need to advocate or be persuasive to get our way or to be in a better position. Now, through grassroots mobilization, we can translate constitutional principles into local languages and daily realities. So there are a lot of locals that may not understand their constitutional rights. As law students, it is one of the duties, I believe, to translate the Constitution, their constitutional rights, their basic rights to their understanding so that they are also not overlooked. As lawyers, we are advocates, we speak for the people. And so the people must know what their rights are in such a way that when these rights are infringed, they can come to you, and it's all part of the advocacy, reaching out and explaining things to them so they can reach out to you when they realize that their rights, their constitutional rights or human rights are being violated. And then you do your part by advocating for them in court. Then the last is strategic litigation. We select cases that create powerful precedents for future generations by the advocacy we have in court. So cases that you might be brought to your chambers or might be brought to you when you become a lawyer and when you're practicing as a lawyer might be cases that will set precedents that future generations will come and rely on. Like the cases I mentioned, someone took it to court and now it's precedent for us to understand that, okay, Article 2 saying a person, this is what a person means. And so in our journey as lawyers, we should also look out for setting these kinds of cases because these are the cases that set precedents and also avoids complications and further explains articles, interprets articles and in the Constitution or other laws. And last but one thing I would like to talk about is the challenges that we face as advocates in Ghana and Africa and in Kenya. Sorry. So advocates usually face political intimidation, especially when you have cases against powerful regimes. And that is something that I think that everyone has seen. Standing against a political party that's in power, standing against a president that has done something, a member of parliament, a minister. These things come with political intimidation. And my advice when it comes to that is to stick to the law, ensure that you are protected, your family is protected. And I'm Christian, so I'd also say that you have to pray. The next thing is judicial independence. Judicial independence remains fragile in many parts of Africa where the courts are weak and persuasion is undermined. So in Ghana, for instance, the judiciary, judges are usually, before you will be elevated into the higher court or the superior courts, you would be nominated and elected by the executive, which does not guarantee judicial independence. Also, the executive is the body that determines how much judges are going to be paid or persons in the judicial service. So I believe that these are also things that can be problematic or challenges that will face advocates in Africa. Then there's a problem with access of justice because some people are unable to afford
I was really trying to afford any more food.
Go to law firms because of how expensive the judicial process is. For different African countries, I'm not too sure of the process, but in Ghana, you have to pay for filing fees and all that. And so sometimes that is aside your payment for the services provided by the firm or by the lawyer. So sometimes let me just say that a vast majority of less than an average person might not be able to afford afford to come to a lawyer or afford to come to a law firm, and therefore will not be able to seek get access to justice. And so I would urge all of us that in our journeys, we try as much as possible that when we get to a stage or a point in our legal career where we can and afford to do pro bono cases, I would urge all of us to try and take at least one or two to ensure that those that do not have the opportunity or do not have access to justice are represented by us, and not just because of clout or just so people will see us as good people, but because we are learned persons and we understand the kind of situations and issues that these people might be facing and might not have recourse to. Lastly, we look at cultural resistance. So for example, when constitutional rights like gender equality and freedom of expression collide, there are deep-rooted traditions that come in conflict with it. But I believe that as we progress as lawyers, as law students, that these dynamics will change due to the education that we might bring to the society. And the last, I would like to talk about the ethics of or ethical duties of advocates. Now, in all of this, let's not forget the moral weight of advocacy. We are not mere technicians of laws, we are custodians of justice. And our persuasion must be grounded in integrity, never distorting the truth. It must be carried with courage, even when the cost is high, because sometimes being a lawyer can be very tricky. In a previous seminar we had with Honorable Zakaria, he made mention of this particular issue about ethics and mentioned that if these decisions that you're going to make, you know that these decisions can possibly cause trouble, do not take that decision, do not make that decision. So it is very important as a lawyer, because we stand for justice, we seek to enforce the law, to ensure that your integrity is not questioned at any point in time, because that destroys the reputation of lawyers, not just you as an individual, because people can, there's this thing of hasty generalization when it comes to the general public. And so if one lawyer does this, the assumption is that most lawyers do it or all lawyers do it. So not just for yourself, but just also for the profession. Also, a persuasion must be carried with courage, even when the cost is high. So imagine as a young lawyer, first year or second year called to the bar, and you have a big case, a case against a political party or an influential person. It might make you feel a little discouraged or question yourself, but I believe that as a law student, once you are qualified to become a lawyer, to represent a person, you should gather the courage to do what you have to do. And the courage comes with the knowledge. When you know what you're about, you are usually very courageous. And once you know and you have studied the art of advocacy, you will be able to communicate. No matter how nervous you are, you'll be able to advocate, you'll be able to make your case known, because the law that you are speaking is right, and because you have mastered the skill of advocacy and persuasion. Now, our former Chief Justice, that is in Ghana, Georgina Wood, reminds us that a constitution is only as strong as the people who defend it. So my last words to each and every one in this meeting is to be as strong, so that when our constitution is questioned, we will be able to defend it. We should be courageous. We should know it. We should master it and be able to defend the constitution, the human rights of individuals, of our friends, our families, and anyone connected to us or that comes to us, because we know the law, because we have mastered the art of persuasion and advocacy, and because we know what is right, and we have the integrity to do so. So I would like to end by saying that the art of advocacy and persuasion is a defense of constitutional rights. In a defense of constitutional rights is both a craft and a calling. It is about knowing the law, yes, but it is also about knowing how to move hearts, shape public opinion, and hold power accountable. In Ghana, in Africa, in Kenya, is indeed across the world. Democratic survival depends on it. And so let's sharpen our tools of persuasion, embrace ethical advocacy, our confidence, our courage, and then stand firm in what we believe in and what we believe is the truth, what we believe is the law, and protect the rights of our citizens. Amen. Thank you. So I'm done. If anyone has some questions, I think we can proceed with that.
Okay, thank you so much, Stephanie. I'd like to recognize the presence of Country Director for Las Kenya, that is Gesimba Atinga, and the Executive Secretary, Jeff Karaoke. Thank you for joining us today. And lastly, I'd like to remind you of the FALAS annual conference happening in Ethiopia at the African Union headquarters. If you've not registered and you wish to attend, kindly you may ask for the link, inquire from your leaders. Thank you. Let us begin taking questions. For those who've sent their questions to my inbox, I'll ask them directly to your preferred panelists. Maybe you don't want to be seen or heard speaking because you're nervous. I have one for Jessica. Jessica, someone is asking, what is the balance between human rights and national security? Which of the two overrides the two? Bearing in mind the situation in Kenya in the 2025 protest, when the Communication Authority shut down a live coverage by the media of the ongoing anti-government protest. Thank you. You may proceed to that, and then if you have any other questions after Jessica speaks, you may put up your hand on the, you raise your hand here on the platform. Thank you.
Thank you very much for that question. I believe it's a question that's, I think, central to everything when we try to reflect on what happened following the Gen Z protests. And basically, I think this cuts across different jurisdictions. There is usually, I would say, excuse by the state to curtail human rights enjoyment on the basis of the protection of national security. And I think the question has been answered already by Kenyan Constitution and international law, because limitation of rights can only be done when it's necessary and when it doesn't defeat the right that is protected. So basically, the limitation of a right should not destroy the very right it's meant to protect. There should be a careful balance between the protection of national security and the enjoyment of human rights. And when we look at maybe the Kenyan Constitution, we see that there is Article 24, which talks about rights cannot be limited. And we do find that the right to protest can be limited, the right to freedom of expression can be limited. However, it should be limited in a way that is reasonable and justifiable in an open and democratic society, and in a way that is necessary to achieve its purpose. So we also have the right to dignity, so a limitation must consider the right to dignity of an individual, and it should not be broad in a way that denies the essential content of the right itself. So national security is a legitimate aim, and a right can be limited for purposes of protecting national security, but these cards have to be complied with, let's say, because we have to make sure that the limitation is reasonable, it is justifiable, the limitation is also necessary. So when we look at what happened in Kenya, we see that the Communications Authority of Kenya, for example, limited the right to freedom of expression and the right to also receive and impart information by coming up with an order restricting the airing of live protests. And the state basically has a duty to protect and ensure that there's free movement of others, that we should prevent looting and violence that can be sparked by protests. And the argument was that, yes, these rights are subject to limitation. However, in reality, as you said, this limitation should be justifiable and should be reasonable in an open and democratic society. And I think this is one of the challenges that we are facing currently as a state, in the sense that, first of all, we see that the peaceful protests that we did as Gen Zs were largely peaceful until they were infiltrated by the state. So are these some of the challenges that we have to look into? Because on one hand, the state will be raising claims that there is a threat to national security, and the other will be saying that our rights are being curtailed. So I think that there is a legitimate concern here. It's a state where there's law that is existing with facts, and the facts in this case are that Kenyans people have gone to the streets, have demonstrated peacefully, and had maybe the demonstrations infiltrated so that the conversation can be turned and the argument of national security can stand, in the sense that looters are brought, in the sense that we even had hunting, that they have been funded by some people in the state. Claims that we have not ascertained yet, but it's a live concern. But on the position of what takes precedence and how we can achieve a balance, I can say that that position of law clarifies that in the event we need to limit a right, it should be reasonable and justifiable in an open and democratic society, and it should be necessary to achieve its purpose. Yes.
Thank you, Jessica. Your answer is very sufficient. I hope you've been satisfied by the answer. The person who had addressed that question. Ongwari, welcome so much from Russia. You may proceed. I saw your hand is raised. Thank you. Dalmas, can you hear me?
Yes, good evening. Sorry for joining late, and once again, sorry. I was speaking to myself because I thought that my microphone was on when it was not. I'm very sorry for that. So with me, I have some few questions, around 3. My first question is to the panelists. First, I would like to thank all the organizers for the panel. It's such a very impressive platform for us to discuss matters constitutionalism and democracy. So my first question will go, how do we balance the international players defending human rights and undermining national sovereignty if we check the case of Libya under Gaddafi?
Dalmas, the question is not addressed to a particular panelist. Anyone who would wish to respond to that, maybe Jessica or Anthony, we may proceed. Thank you.
I'll request that the guy pardons the question.
Okay. Ongwari, you may pardon, kindly pardon.
Okay, asante. The question is, how do we balance the international players defending human rights and undermining national sovereignty? Here we are checking the cases of Libya as a country under its leader Muammar Gaddafi.
Okay, thank you. Okay, I'm trying to connect that question. You're asking how do we balance the state sovereignty in contrast with or maybe
in
if
contrast
Jessica
with national sovereignty.
How do you balance national sovereignty in contrast with?
In contrast with the international organization defending human rights in a particular country. I think Libya was uprising around 2011. The story behind it is that Gaddafi was killing civilians to defend his regime. So I think now you can connect.
Okay, yeah, now I get you. So I hold the view that I'll say that there's no straight answer to the same, but it depends with the case at hand. For example, you may find that yes, and I believe in every constitution, at least every country, one of the first articles is in regards to the state sovereignty, something that must be respected. But the time comes when we cannot bank on state sovereignty, where you cannot tell us that let us deal with our citizens the way we know our citizens. So at that point where we realize that you're committing atrocities, you're committing harm in your country, you cannot come and say that state sovereignty should prevail. So to me, when it comes to balancing, state sovereignty ought to come first. But state sovereignty should only be respected if and only if there is a justifiable reason as to why state sovereignty should be upheld. So in a scenario where there are atrocities such as what we saw in Rwanda and so on, even what we have been seeing in Kenya recently, where the youth are killed in the streets and so on, then the president says we cannot handle this matter at international level and so on. I'm in objection of that. If you cannot address our matters as a state, then let the international space come to assist and save the lives of the citizens of that country. Yeah, so it depends. It's on a case-to-case basis. Back to you, Bunene.
Okay, thank you so much, Anthony. Jessica, you address your hand. You may proceed.
Okay, I just wish to add to the conversation and agree with what the other panelists have said. I think there is a balance that we have to strike between isolationist independence, whereby people are isolated in their independence, to pragmatic sovereignty in the sense that we encourage international players while also ensuring that our national interests are observed and our independence is observed. Yeah, so we cannot entirely say that the inclusion of international players will lead up to an adverse effect, because sometimes the state itself is the perpetrator of human rights violations. And I think there is set out in international law thresholds as to which other states can intervene in the event that there are human rights violations that have passed a certain degree. So I think in that event, then we should have other international players coming in to aid in ensuring that human rights observance by a state is met. However, in the instance that has been cited, which involves the death of Muammar Gaddafi in October 2011 following the NATO-led intervention, I think there is a lot we can learn from that, because there was a power vacuum that was created. First of all, let's not even belabor on the death itself, because a lot of people have a lot to say on that, and I think bedeviling, or rather looking into that issue, would be an issue of another day, basically, because we'd have to look at, okay, which power was coming in, what was Gaddafi doing in that state, the rebel forces that he is claimed to have been controlling, what were they doing, and all that. But then I would say that in that event, we'd have to pick out some lessons from it, because we see that this intervention that was then when NATO came in overthrew what they called a tyrant without a legitimate national reconciliation process and without a framework for governance that can lead to that human suffering that they were going in to solve to be quelled. And then we see that there has been regional instability rather than what they sought to end, So I can say that international players are not, necessarily a bad thing. They help at some point. But I think that strategy is the most important thing when it comes to preserving a nation's independence and also ensuring that human rights violations are met with the force that they have. Because at the end of the day, we cannot say that we're living in isolation, and the international community can also come to aid in scenarios whereby a state has broken down to the point that it cannot even help its own people. So I think it's a very weighty conversation, the conversation on Libya and what ensued. But I can say that there should be a balance between the aspects that I've raised.
Okay, thank you so much, Jessica and Anthony, for that answer. I believe it's comprehensive to answer what it sought to understand. Now, Ongwari, I'm going to ask you to complete the remaining question, maybe one or two. There were two, yeah, and kindly you may address.
Okay, thank you so much. Thank you so much. Okay, I will address this to Jessica, but before I address that, I would like to comment.
We cannot hear you.
On what the first, if issues of bringing in. Okay. Okay, let me use my microphone now. Okay, now can you get me?
Yes.
Okay, I agree with the first speaker, but I differ somehow, Jessica, with the matters of bringing in international players. So actually, the matters of bringing in international players has injured many nations, starting from Serbia during that time in 1993, the bombing of Serbia that happened during the presidency of Bill. I think it was the same thing with the Kosovo state when the US forced Kosovo to be a free and independent state from Serbia that caused the bombing. And they claimed to be protecting human rights, which was not true according to them. And it's almost the same thing that happened
agencies were running was leaderless, decentralized, and it was done in a peaceful way. But then we see what the outcome was, or rather the response that it was met with was, police brutality. And that in itself shows that the NPS is not doing what it's supposed to be doing. But we agree to the fact that there was, for example, the person who shot a person who was selling something in the street, right? The person that was selling masks in the street, let me not put it generally. We see that police officer was, prosecuted. We see that there's an inquest that's ongoing against the killing of Rex Masai, but still there is a disconnect between what we expect from this institution and what's ongoing. Because, for example, if a member of a person who's serving the nation comes up and says that people should be shot, just because they are, protesting, they should to kill order. It happened a lot, and we have not seen any action by the state on that. We have not seen any action on the part of the Office of the Director of Public Prosecution to institute cases against such people. However, as it was said before, there's a sort of selective application of the law, because other people are being castigated for small things, such as coming up with a website to help the public. And the laws like the cyber, I think it's one of the laws was being, I think it's the Cyber Crimes Act, yeah? It was being extrapolated in all ways to ensure that such a crime, quote unquote, is held to the, non-existent laws that they had to come up with. So I can say that, in essence, the Office of the Director of Public Prosecution and the National Police Service have a long way to go, because the mandate is very clear, but that mandate is not being discharged in the way that it is. I would say that the operations of most of the entities in the country are being controlled by an entity that I will not disclose. I think everyone knows. And that's some of the problems we're facing as a country. Like, the justice is not being served to the people that it needs to be served to, and institutions are lagging in their responses. Institutions are selectively applying the law, and institutions are struggling to ensure that accountability is or justice is served to the right people. And yeah, I think we can even mention the killing of Albert Ojwang in police custody. Like, the number of extrajudicial killings that have happened in the past year is quite alarming, and the responses that we get following that is quite alarming as well. And I think also we cannot entirely talk about this conversation without even talking about the people, right? I feel like also there should be civic education, because people sometimes just take this as the norm. Like, people see that people dying. I know of even some of my close friends have died, but they have not followed up these issues because justice won't be served, or people will just say, it was their time, we didn't expect them to die this way, or anything of that sort. So yeah, I would say that we are in a really terrible situation, but I hope our advocacy will aid, because at the end of the day, I think that in as much as it's a journey to attain the Constitution's, fullness, its observance to the fullest, I think we should contribute to the journey in the way we are, because if you look at even the Gen Z process again, you'll see that there's a formula that was somewhat effective. We have never seen a seismic shift of this magnitude in the country's political culture. And unlike previous movements whereby there were leaders, there was centralization of leadership, and the digital narrative was sort of confused, we see that currently, at least, there's a shift in the country, and there's a shift in the nature and approach to the things that we're talking about. So I'd say that these two institutions are not at the position they should be, but we cannot stop at that. We should look at how we continue mobilizing these institutions to live up to their constitutional mandates, their legislative mandates. And I think this platform in itself is one of the platforms that we're using to target the future occurrences that we see. So yeah, they're not there yet, but we'll try to push where we can. Yeah.
Thank you so much, Jessica. I believe we're all okay. Any other question? Kindly raise your hand and brief at least one question at most. Okay. In 3, 2, and 1. I believe there is no question, so we may proceed to conclude. Let me take this opportunity to thank you all for finding time to be here today. It's been a very wonderful conversation listening to Jessica and Anthony. I believe they're all experienced to defend human rights. As you know, in a society, the primary human rights defenders are lawyers, NGOs, and the independent government institutions, which we think they are not really independent per se, because they're still under control of the executive power. So I believe we all put whatever we've learned today in practice as lawyers and people in the society. It's our duty to do so. The matter of interventions in states, I'd say it all depends on the intent of the intervening power, because for those who have been in Instagram, you see that people criticize the United States because of its military power, and they tend to intervene whenever they want. They think laws don't apply to them. And in our case today, it was NATO, and the US is the major power in NATO. You see, they spend billions there to arm it. So as we argue about human rights, our state sovereignty should be respected. Thank you so much for today. Have a great evening. We may proceed to quit. Thank you.